Hi, our guest today on the Encrypted Economy is Professor Yuliya Guseva. She is a professor of law in Rutgers, and she has written 4 journal articles relating to the regulation of digital assets, with particular attention to the SEC's regulation of digital assets. It's a fascinating topic that will dominate discussions in 2022 and beyond. There's so much to talk about here that I broke it up into 2 episodes. In this first episode, we take a look at the SEC's digital asset enforcement actions and whether those actions viewed in the aggregate are achieving the SEC's mission. Based on a review of enforcement actions and a worldwide review of enforcement, she examines why the SEC was actually accomplishing its mandate effectively with regards to digital asset regulation, and also why the SEC's current approach with regard to digital asset regulation is simply not achieving its desired ends. The SEC has the most active enforcement posture with regard to digital asset regulation in the world, but it is quickly reaching, it is probably already at an unsustainable position, and the U.S. is going to need to decide whether it wants to foster digital assets or endeavor to take a heavy-handed approach where projects are subject to regulatory jurisdiction from a number of regulators and then drive this developing market off its shores. Undeniably, right now it is leaning toward the latter, and the impact of that probably merits its own separate discussion and analysis. So with this noted, I bring you the first of 2 episodes with Professor Guseva. The next one will be published in a few weeks. Welcome to the Encrypted Economy, a weekly podcast featuring discussions exploring the business, laws, regulation, security, and technologies relating to digital assets and data. I am Eric Hess, founder of Hess Legal Counsel. I've spent decades representing regulated exchanges, broker-dealers, investment advisors, and all manner of fintech companies for all things touching electronic trading, with a focus on new and developing technologies. So today, the Encrypted Economy is excited to have Yuliya Guseva on the podcast. Professor Guseva, I guess I'll call you Julia, is that okay?
Please do.
Is a professor of law at Rutgers Law School. She teaches capital markets and corporate law, international financial regulation, fintech, and crypto. Now, she's been very active publishing articles on crypto over the last couple of years on crypto regulation, like 4. One is still coming out, I think the last one, I believe. And you certainly you certainly took on the task at the outset, right? You knew what you were getting into, and you're like, I don't care, bring it, right?
Well, Eric, thank you so much for inviting me to talk about my research with your viewers. It's both a privilege and an honor and pleasure to be here. Indeed, guilty as charged. I've been writing a lot about the SEC and crypto lately, and I'm also the head of the FinTech and Blockchain Research Program at Rutgers. About 2 years ago, the Rutgers Center for Corporate Law and Governance organized the FinTech program. So I have been running it for 2 years now, and I'm not working alone in some cases, but there is a research team. We have a lot of students, and I have several co-authors at the moment. But the papers that you mentioned are indeed about the SEC, and I have authored them alone mostly. So we are looking at a very strange structure in the United States. We have crypto regulations, but we don't have crypto regulations. What do we have? We have a pretty outdated regime based on the pre-crypto commodity and security regulations. And we have 2 separate commissions, which is kind of unique. It sets us, the United States, apart from other jurisdictions. Many of them do not have a separate securities and a separate commodities regulator, right? It's all combined under usually an umbrella of one regulator, but that's not how it historically developed in the United States. So we have the CFTC, the Commodity Futures Trading Commission, and we have the SEC, the Securities Exchange Commission. And both of them pursue slightly different approaches to crypto, with the CFTC being more flexible, and the SEC, by contrast, being more enforcement-based. It has always been more enforcement-based compared with the CFTC, but we definitely see that in crypto. And an important problem is that the laws and regulations have not been updated in almost 100 years. They have been. They were enacted back in the 30s in many cases, right? Also, the SEC has been using a very interesting test to determine which crypto assets are within its jurisdiction. And I'm sure many of your viewers know about the Howey test. And the Howey decision dates back to 1946. So prior to Howey, what we had was two definitions under the Securities Act and the Exchange Act. Basically, both provisions are identical. They give a list of securities. They enumerated, let's say, shares of stock, bonds, notes, and other conventional securities. So everyone knew what those meant. But as a catch-all provision, Congress added investment contracts. And the meaning of that term, an investment contract, was unclear up until 1946. And then came the Howey decision, decided in that year. And in that decision, the court said that this ambiguous term, investment contract, which was not defined by Congress, it means that someone invests money in a common enterprise with the expectation of receiving profit, and that profit should come from the efforts of another. Or the Supreme Court originally said solely through the efforts of another, but later on it relaxed, and lower courts also relaxed that solely qualification, so it's through managerial and entrepreneurial substantial efforts of another. So that's what we have. If you look at the definition, you can sweep in almost any financial instruments under the term investment contracts. And this is what the SEC did in many cases with crypto asset securities. Some of them indeed were very similar to common shares of stock or even bonds or other conventional securities, and definitely to investment contracts. But others were not. Nevertheless, because the Howey test is so flexible, we call it a functional test. It's really broad. This allows the SEC to expand its definition and bring more and more enforcement actions against issuers selling crypto assets or exchanges trading those crypto assets. The most recent case was against Poloniex. Of course, that was a settlement back in August 2021. Oh gosh, it's last year, August last year. And Poloniex made a mistake. They looked at the Howey test, but they decided to list securities that they considered all crypto assets. They were considered at a medium risk of being classified as securities. And if an exchange is selling securities, it must register with the SEC as such or find an exemption, such as Regulation ATS. So what the SEC did, it brought a range of enforcement actions, starting with issuers in the so-called ICOs, initial coin offerings, which were very popular back in 2018 and 2019. And then it slowly proceeded to go after the infrastructure-related entities, such as exchanges. So that's what we have in the United States. There is no formal rule, to summarize. We have a very capacious, flexible, and functional Howey test, which means that the SEC's jurisdiction is broad. And the SEC has not been hesitant in bringing those cases against crypto entities. So that's the status quo in a nutshell.
Great. Well, thank you for that backdrop. So we're going to start to work our way through some of the topics in your paper and explore them. You've written 4. I'm going to summarize them real quick. Crypto enforcement around the world, the SEC digital assets and game theory, when the means undermine the end, the Leviathan of securities law, and enforcement in digital asset markets. I think I left one out, didn't I? Or
yes, digital assets as shares of stock and bonds. That one was published in December last year. No, actually, January last year in the Maryland Law Review. Right. That was the first paper I wrote on crypto. And in that one, I looked at various types of offerings and said that, well, the SEC got it wrong, especially in cases such as Telegram, because issuers were selling securities under the so-called SAFT framework, or something similar to that, which involved two stages. A token, which is a security, which would later on transform into non-security. My take was different. I said that the court in Telegram was completely wrong, because tokens and securities can exist as completely independent and separate financial instruments. A token would be a commodity, and an investment contract would remain an investment contract. So by conflating the two into just one single concept, as we all know, the court shut down Telegram's project.
That's the integration doctrine, which is something that's very dangerous because it makes it hard to plan, right?
That's true.
And so before we even get into it, what assumptions did you find yourself going into these four papers with at the get-go that changed over time? In other words, what did you like? I'm sure you learned a lot in the process, but were you surprised at anything that happened over the course of these four papers where you had come at it with a certain perspective on it, and then by the end of writing all four papers, you had a different, or you'd learned that you had to kind of really, because obviously as you do research, your views change over time. Just curious, what were some of the more notable changes that you found that kind of surprised you when you look back at it?
Well, obviously, as I was writing the papers, the SEC was breaking more and more actions and making more and more statements. So that obviously influenced the flow of my research. And another point I think was quite interesting, and I discussed it in When the Ends, the means undermine the ends. So I'm paraphrasing Machiavelli there. The means of the SEC are enforcement, and the ends are bifurcated. It's protecting investors and facilitating capital formation, plus maintaining market efficiency. So we have several objectives of the SEC. These are the ends. But the means, as I said, are enforcement under this very vague and capacious Howey test. Now, I originally thought, and I talked about that in the paper on game theory, that up until mid-2019, the SEC was proceeding through relatively clear enforcement strategies. And then something happened, and in Kik, Telegram, and later on Ripple, the SEC switched its strategy. And whenever a regulatory strategy becomes unpredictable, the market reacts in unpredictable ways. In particular, it may start avoiding the regulator. Moving abroad is a good example. And this indeed has happened with certain projects, crypto projects. But at the same time, some issuers may prefer to start looking for ways of perfunctory compliance, the least costly compliance options. And this is what I thought would happen around mid-2019. But actually, it happened a little bit earlier. And this is what I found when the means undermine the ends. About 2018 or early 2018, the issuers preferred to comply with the securities law in the very same least costly compliance option that I thought they would do in 2019. Starting in 2018, what happened is the issuers decided to file Forms D, and since some of your viewers probably do not know much about securities law, and I'm sure many do, Regulation D is a private placement exemption, under which an issuer files Form D sometime after the sale, the first sales of securities. So in 2018, even though the doctrinal questions, whether the Howey test should apply, whether many crypto assets were securities, those doctrinal questions were not settled yet. And nevertheless, issuers prefer to comply preemptively with the securities law requirements. But because many of them could not comply with the full scope of the Securities Act requirements and register their crypto assets as securities, it's really expensive, and it leads to substantial liability implications, possible liability implications. So issuers prefer to avoid that, and based on their cost-benefit analysis, they started filing Forms D, trying to fit their offerings under Regulation D. Unfortunately, for the SEC and for its goal to protect investors, Regulation D, in many cases, does not provide for mandatory disclosure. While the SEC is trying to promote efficient markets, provide markets with more information, protect investors, it effectively has nudged issuers towards the least costly compliance option. So that's how my research proceeded. I started with a model, a game theoretical model, which suggested that it should happen pretty soon. But I missed the point that it had already happened starting in 2018. So I was 1 year
Right.
off.
So, and Reg D has, accredited investor implications that the purchasers have to comply with under the 506B or 506C. And, I guess that means that the retail investors are, aren't going to be given the same access to these projects.
That's a very important observation. Thank you for bringing it up. So let's talk about the accredited investor definition. In the United States, we have this concept that some investors who are sophisticated, they do not need the full protection of the securities law or the full information required by the Securities Act. That was the Ralston-Perini decision by the Supreme Court. And to quote the Supreme Court, investors who can fend for themselves technically do not need the full scope of the securities law protection in private offerings of securities or non-public distributions. And the SEC looked at that case and decided to develop this accredited investor definition, which technically is not based on investor sophistication per se. Instead, it looks at the financial status of investors. It looks at investor assets, their investments, and the wealth or their income. So that's the gist of the definition under Regulation D. And this definition of accredited investors is the touchstone for who can participate in which placements and what are the issuer's obligations with respect to those investors. So Regulation D has two rules, 504 and 506. Let's put 504 aside. It's not very often used. 506 is the most popular rule under Regulation D. And once again, Regulation D is the most popular private exemption in the United States. So 506, it has two parts, B and C. Under B, some non-accredited investors can participate, meaning smaller investors, smaller institutions and retail investors which do not meet a certain wealth threshold or net asset threshold or the income threshold. Under C, only accredited investors can participate. And there are no limits on how much an issuer can raise in Regulation D under 506, either B or C. Also, the difference between B and C is that under C, an issuer can reach broader swaths of investors. It can use general solicitation methods, including online ads, newspaper ads, you name it. And this is what indeed many crypto issuers use. They use social media platforms, Telegram, for example, and many others. Consequently, they reached a lot of investors. But before they sell securities to those accredited investors, they have to check, they have to verify that the investor status is accredited. So I think that's clear. We have accredited investors, they can participate in private placements, but under 506C, an issuer advertising broadly must make sure that the purchasers are
and the
accredited.
verification process can be much more expensive and subject you to liabilities. So B is the safe one for most of us.
B is the safe one, but as the SEC itself established a couple of years ago through a number of studies, issuers prefer not to sell to non-accredited investors.
Right.
So also there is a quantitative limit. There can be no more than 35 of them. But putting that aside, several crypto issuers, starting with Block 1, ran into problems with both the SEC and also with verifying that some investors were accredited or not accredited. Block one had to pay a substantial fine, which actually was not that big compared with the total amount raised. But it wasn't the only issue. A couple of other crypto issuers also had problems with verifying that all investors were indeed accredited. And because crypto placements are global, some investors participate in so-called investor pools, and in those pools, all underlying investors must also be accredited. But it's really hard to check that if the pool is originated, let's say, in the British Virgin Islands, for example, or somewhere else. So it's really hard for the issuers to comply with the verification requirement.
Yeah, I mean, for a lot of BVI pools, they typically advise staying in BVI and excluding U.S. investors altogether.
But it's really hard to exclude U.S. investors. So Block One actually tried to do that. They tried to geofence IP addresses from the United States, but they were very unsuccessful, hence the enforcement
I guess
action.
if you do a public offering, but I guess if you do a private offering, you're probably a little safer. You could do like a big pool in BVI to a private offering, but then the question is ultimately when you do release tokens into the private market and it's trading in the secondary, that's where I guess geofencing comes into play.
That's true. If there is an active secondary trading platform, and those securities are flowing back into the United States, the SEC may find it problematic and bring in enforcement action.
That'd be an interesting enforcement action if everything was done outside of the U.S. and then it flowed into the secondary market and there was geofencing. Hopefully.
And we also always have to remember that there is the primary market where issuers of crypto assets are selling crypto assets, which may or may not be securities, but the SEC views most of them as securities. On the other hand, we have the secondary market, and this is where we again run into a number of problems. Because securities sold under Regulation D are supposed to be restricted. You cannot freely sell them. So a lot of issuers found that problematic as well.
Yeah. So, and I think this sort of cuts into a little bit the crypto enforcement around the world. Now, the SEC is not the first time they've been accused of regulation by enforcement. Oftentimes, where there's not clarity, that's, they're an active regulator and they will enforce. And then people will say, well, we got to get clarity. And in the absence of changing the rule or direction from Congress, that's the direction they go. But do you think that it's worse in the case of crypto versus prior periods?
Eric, that's a tough question.
That's your fifth
yes
paper, right?
No.
I'm just kidding. I'm just kidding.
No. That was the second paper. It was published in March in the Southern California Law Review. And I wrote it with several co-authors because it was a very data intensive exercise. We looked at 24 jurisdictions, but managed to find some semblance of enforcement actions in only 14, including the United States. And the main conclusion of the paper was that the SEC uses what I call the heavy weaponry of court actions and enforcement actions, administrative actions, while other jurisdictions, including such major jurisdictions as France, which is getting pretty crypto-friendly, the UK and many others, they are going with what I call a light touch regulatory approach. Specifically, they're blacklisting certain companies on the regulators' web pages, or they're issuing warnings with respect to certain companies. The SEC is completely different. It relies on courts, it relies on ALJs, administrative law judges, it imposes significant fines. The disgorgement orders can be humongous, to the tune of $1 billion. So the SEC is different in terms of not only the quantity of the enforcement actions, but also its intensity. Now, back to your question, how do we fare compared with the rest of the world? Well, yes, there is more, but is it in line with what the SEC has been doing for years? Actually, it's a very old institution. It's almost 100 years old, a little bit less. there have been previous studies which showed that the SEC is indeed the most active enforcer. And to name a few authors, Coffey, Jackson and Rowe, I actually list all of them in the paper, of course. It looks like our results are in line with those previous studies. The SEC has the largest budget compared with other jurisdictions. Its enforcement division has always been the most active one compared with other countries. So in this sense, crypto enforcement is not that different. On the other hand, the length of the enforcement program is a little bit surprising. We've had crypto offerings back in 2015 and even earlier. Well, I'm sure some people would say that Ripple offered a crypto security, which may or may not be true. I actually think that XRP is a cryptocurrency, not a security. But that aside, some people can also say that Ethereum offered securities originally, Ether, when it first launched Ethereum, the blockchain. And later on, Ether became a commodity, at least according to the CFTC. So we have those early offerings, and we have an avalanche, and they don't mean the blockchain, an avalanche of offerings in 2000, starting in around 2017, or even earlier. So it's been, 4 years now? And the SEC still hasn't come up with some form of a formal rule or a more specific and clear guidance for crypto assets. And this is what's surprising. The SEC keeps enforcing pre-crypto regulations. And as I mentioned in the beginning, by enforcing pre-crypto law, they're nudging the issuers towards compliance with the least costly compliance option for the issuers. But that option is not beneficial for the investors. So that's what is very problematic about the current SEC enforcement program.
And then, and I guess that sort of gets into your game theory paper. Whether this approach is actually working. And I also noted in that paper you cautioned against taking the perspective that viewing the SEC as an overemphasizing enforcement and investor protection for crypto and fintech may not be accurate because it's not achieving those objectives. Could you develop a little bit on this?
So I made several points in the game theory paper, the SEC Digital Assets and Game Theory, to name the full title. On the one hand, the SEC is always trying to protect investors. And this has been the primary goal of the SEC since the Great Depression. Or, excuse me, not the Great Depression, the post-Great Depression statutes.
That's what triggered it,
of course. Exactly. But on the other hand, its other two objectives are facilitating capital formation and promoting market efficiency. Market efficiency is related to the informational component of the markets. That information has typically been provided through two venues. The first one is the market itself, market trading. You can learn a lot from how people trade. The second one is issuer disclosure. So that second prong, issuer disclosure, is really problematic because now we live in the private placement world, which doesn't have mandatory secondary issuer disclosure. So in this sense, the SEC is not protecting investors, nor is it promoting market efficiency. On the other hand, if you look at the enforcement program, and this is where I tried to emphasize in the digital assets and game theory paper, that the SEC started with a predictable, or I would say a relatively predictable enforcement strategy. It knew that it was enforcing an unclear law and the functional test, which was too broad. Let's say the Supreme Court in Rutgers said that the legal clarity is an important component, which helps market participants to act in accordance with legal requirements. If they don't know what to comply with, they cannot comply with something very ambiguous, right? And this is what I emphasize in the game theoretical paper. The SEC knew about that. because it's an expert regulator, and I have deep respect for the SEC and its staff. So what they try to do, they try to use some game theoretical techniques. They issued threats, they issued warnings, they proceeded with providing commitments, something like, come to us, talk to us, and we will reciprocate with cooperation. We will help you modify your project, etc. Well, some companies, starting with Telegram, found that those commitments were wrong. But up until mid-2019, the SEC was following through on its own game strategy. And through its enforcement policies, it provided the needed clarity to the market. So it basically said, okay, we have the functional test. We know that it's imprecise. We provide you with the framework for digital asset analysis, which the staff and FinHub specifically issued in April 2019. We know it's all imprecise. We're giving you multiple examples how you can comply. And come to us, talk to us. That was very clear. That was a clear signal to the market. And then starting with Kick, something happened. This cooperation undertones just disappeared. And we saw that especially in Telegram and later on with Ripple. And consequently, in the second half of its 4-year enforcement program, the SEC showed some kind of dynamic inconsistency, which means that now the market doesn't know what to expect from the SEC, except a very expansionist approach towards enforcement. So we have two periods in enforcement. One is very strategic, very clear. The SEC is trying to signal to the market how to comply and how to talk to the SEC and cooperate. And in the second half of the enforcement program, the market simply is confused. And the major cases that I described in the digital asset and game theory paper is that we have Telegram. Telegram was a very strange case, which led to the project being shut down. Now we have Ripple. And the community is watching very closely what's going to happen with Ripple. It's also very unclear. For some reason, the SEC went after a relatively successful crypto project, which has been around for 9 years or even longer than that. Many perceive XRP as a cryptocurrency and a commodity, not a security. And finally, there were no allegations of fraud. And yet insiders were charged. Why do I say yet? Why is it surprising? Because based on my research, insiders were charged only in 2 cases not involving fraud, and Ripple happened to be one of them. Usually, when fraud is involved, and we all can agree that fraud is bad, the SEC is doing a good thing going after swindlers and fraudsters. It's rooting out fraud. It's preventing the so-called lemons problem in the crypto asset market, and it's performing a really important mission. Yet, when it comes to registration violations, that mission is not that clear. Now, it's also unclear to me why the 2 insiders were charged in Ripple. When insiders are charged in fraudulent cases, and let's say a crypto asset firm it's 2 founders who are the actually culpable parties, then it's clear why the SEC is going after them. But in larger cases involving simple registration violations, that's puzzling to me.
Interesting. Yeah, I can tell you anecdotally in my practice, I'd say my digital asset practice is largely advising projects not to be in the US. Right. And it does sort of constrain the amount of clients because a lot of it is like saying, go somewhere else and somebody else will ultimately represent you and facilitating that path to get there. But honestly,
You shouldn't do that. Eric, it's not very patriotic.
But you have to represent your client and even and anything where you're contemplating doing some sort of token issuance that's going to trade on the secondary. How can you even Reg D? Like if you issue tokens under Reg D, they can't trade. There's all these questions about what happens in the secondary. So it's largely, my first question, somebody comes to me, why do you want to be in the United States? Like, right? Like, don't. And I'd love to manage it differently. And again, in a lot of cases now, it's just Reg D more equity focused. I don't know if that's achieving everybody's objectives. That's a much more narrow approach. But I can tell you, front and center on the front lines, that I am actively encouraging projects to go offshore, not in the United States. It's just.
And that, yeah, I agree with you. That's one of, I think, very momentous and huge problems for the United States, that capital can flow abroad and that investors and issuers can relocate. Capital is very mobile, and crypto issuers are very mobile as well. So it's important to foster innovation within the United States, provided, of course, it's socially beneficial innovation. We're not talking about fraud and fraudulent crypto asset offerings and sales. But I think there are several proposals out there which can help to solve this problem. And one was circulated by Commissioner Peirce back in April 2021. She proposed her second reiteration of a digital asset safe harbor. And that rule was later on embedded in a bill introduced in the House back in October 2021. I'm not sure if it will go anywhere, but I think it's a viable framework for how we can foster innovation without exposing investors to the risks that they currently face.
One of the challenges, I think, that the safe harbor proposal faces, although I think it's a good start, is that it's become very politicized. And so when things are bipartisan, they need to be embraced, particularly in this climate, because it's harder and harder to find that common ground, particularly as it relates to crypto. When you talked about cooperation, do you think the SEC is no longer cooperating with crypto projects?
Oh, well, unless we get access to the internal data and conversations happening within the SEC, it's hard to tell whether there is any cooperation going on. Going back to Telegram, because it was reflected in their pleadings, Telegram's attorneys, Telegram was represented by Scan and Arbs. They claimed that the issuer tried to cooperate with the SEC for a year, produced multiple memoranda, papers, changed its project according to the SEC's suggestions. Coinbase, based on that Twitter exchange, seemed to have done something similar, but their lend program was shut down. Coinbase itself preempted the action and closed down the program. It seems that in certain cases, the SEC is not very receptive to cooperation. I cannot tell whether it's related to the underlying projects per se, or it's the propensity of the SEC to send a certain programmatic signal through non-cooperation. But as I said before, it creates dynamic inconsistencies. When you promise cooperation so openly, when you tell to the market multiple times, not only through the framework on digital assets, but also in multiple statements by the former chair and various commissioners, come to us, talk to us, you cannot reciprocate when a company starts cooperating. There is always some kind of common ground how we can foster cooperation and productive innovation, and at the same time protect the investors.
I've heard anecdotally, at least last year, and I don't know to what extent it's changed, that sometimes when projects would approach the SEC to confer with them, and I think it's just, again, it kind of feeds right into what happened at Coinbase, that oftentimes they would get an inquiry letter from like enforcement or something afterwards, and based on largely the information that was shared from their meeting where they sought additional guidance. So, probably, that does, without knowing the details of what that guidance meeting was, it could have been like, can I steal money from old ladies? And oh my God, I got an enforcement letter. But like, putting all that aside, I don't get the sense that that was really the scope of it. So, and I've heard more than one instance of that. So,
there is always a problem with anecdotal evidence. Even though economists would say it's unreliable, it is very important because it creates a perception. And a certain perception is key to shaping the behavior of crypto companies or any company or any firm whatsoever. So if there is a perception that the SEC is using cooperation as a fishing expedition, then we have a problem. The SEC depends on cooperation with the market. What happens when the firm, a good-natured, bona fide firm, comes to the SEC and says, I have a project. Could you please help me launch it in a compliant way? Or this is what my attorney suggested. Do you have any objections, etc.? So the firm is completely bona fide. It has a socially beneficial project. It's a very interesting innovation. At least this is what the firm thinks. Now, the SEC can use that to form what economists call a separating equilibrium. If you're a good-natured firm, you want to comply, you fall into the category of the bona fide firms. If you don't come to us, and hence the separating equilibrium, you're probably bad. There is something fishy going on about your project. So it helps the SEC to identify good firms and distinguish them from the bad ones. So if a regulator, not just the SEC, any regulator, is using this cooperation as a fishing expedition, we have a problem because there is no separating equilibrium. And everyone tries to pretend that they're complying, but not exactly disclosing anything to the SEC. So that's problem number one. Problem number two, the SEC really depends on the innovators and their propensity to cooperate. Why? The innovation is developing too fast for the SEC to catch up. The SEC is constantly playing this catch-up game. It cannot say, okay, this is the new innovation and we should regulate it this way. Instead, it's always in this reactive posture, right? Hence, a regulation by enforcement in many cases. So let's take DeFi. The SEC is still bringing actions for registration violations against ICO issuers. But that happened back in 2019, which is ages for the crypto universe. Now we are talking about DeFi. Now we are talking about governance tokens. Some of them may be very similar to shares of stock, or maybe partnership interests. Consequently, it looks like some issuers, some projects and developers are working in a completely different universe, which is yet to be regulated by the SEC. So the SEC has to play this catch-up game unless it establishes good cooperation with the market.
And I guess one question I have is that, Chairman Gensler has said repeatedly, if you have a crypto project, come in and talk to us, right? And against a backdrop where crypto projects that have come in that have endeavored to do this have been, you could say, punished. Now, the idea it shouldn't be that if you're going in seeking guidance from the SEC that you get an exemption or a grandfathering of whatever you do. But if there is a tendency to that the projects going to the SEC are not being, that there isn't a cooperation, that there isn't something positive coming out of this, then how does the SEC regain that sort of cooperative tone? Like if you continually say, hey, come in, talk to us, we'll be cooperative, and then you punish people, and they're like, no, that was just come in and talk to us, no, and then you punish them, and it's like, how do you regain that engagement that actually facilitates, a model where you're working with actors who are trying to get to the right place and cooperating, and then those that aren't, those that are just going on their way, you're taking appropriate action against them.
So I think economics and game theory are very clear that it's important for regulators to build trust between themselves and the market. It may be very easy to undermine that trust, but in certain circumstances, it may be very difficult to regain and rebuild that trust. In the case of the SEC specifically, you're absolutely right. If we have this repeated pattern of inviting cooperation, then slapping firms with fines or disgorgement or shutting down projects, and this pattern is repeated over a certain period of time, the market doesn't trust a regulator any longer. On the other hand, first, the SEC's composition changes all the time. Secondly, it has its expert staff. It has wonderful people, highly ethical people, and FinHub is indeed the hub for cooperation and expertise. So I expect that the SEC's policies can change, and they will change at a certain point. The SEC perhaps maybe needs to get together, put political differences aside, and think about the proper either safe harbor or a new rule for crypto. And I think that may happen, and I'm sure the market will welcome it. After all, the United States has the largest capital market. I recall what Binance CEO said once. It said that Coinbase cornered the US market, and it's a big market. Everyone wants to be here still. Even though some projects are migrating abroad, the United States still has the strongest capital market. It's one of the most efficient markets in the world. And unless we miss that opportunity to develop more trust and provide proper rule to the market, we can remain the leader in crypto and digital assets in general as well.
Going back to the game theoretic approach in achieving results, Chairman Gensler has said that he would need to triple his enforcement staff to effectively, at least triple his enforcement staff to effectively police the crypto market. Do you believe that spending, tripling the staff budget for the SEC and enforcement, do you think that would achieve better outcomes?
Better outcomes? Well, define better.
Well, do you believe that it would better achieve the market ends, understanding that there may be a cost inefficiency to that, but I just sort of like, given your research, what your thoughts are on that?
You mean whether there will be marginal diminishing returns to the original investment and enforcement? Yeah, probably at some point. Well, the SEC will proceed with more enforcement actions if its staff is tripled. That's obvious. But whether it will result in better enforcement, well, that's not clear to me. To date, well, let's take issuers. Let's stick with the primary market where issuers are selling securities to investors. Let's look at the issuers. So far, there have been two avenues for the SEC to proceed. One was fraud. And to the extent that there is a lot of fraud, maybe SEC enforcement is good and there should be more of it. But on the other hand, the second largest category was simple registration violations. Registration violations including Section 5 of the Securities Act, which applies to issuers offering securities to investors publicly, and Section 5 of the Exchange Act, which applies to exchange registration. But it was primarily about Section 5 of the Securities Act, issuing securities, selling them to investors. And this is where the SEC repeatedly and constantly, ad infinitum and ad nauseum, repeated in the litigation releases. We bring these enforcement actions because the registration violations occurred and investors were deprived of material information, which can be provided only through the lens of the Securities Act and Section 5. It's a problem because as I mentioned before, issuers prefer not to do Securities Act public offerings. Almost everyone goes with private placements, which means investors de facto do not receive material information which is required by the Securities Act. That's point number one. Point number two is that the market, and this is the work in progress that my co-authors and I are currently working on, the market reacts negatively to all sorts of enforcement by the SEC, including registration violations, which means that the market perceives enforcement as something not costly. It is possible that the market doesn't derive any benefit from issuer disclosure under Regulation SK and the Securities Act. For example, If the main asset of an issuer is its code, which is audited, and not by, let's say, Deloitte or PwC, but by some third-party auditors who operate in the crypto world. Everyone trusts them, but it has nothing to do with the balance sheet per se. So the market looks at the code. Then the market cares about the talent. They look at the background of the developers and they say, yeah, they have developed a few very good projects. We trust them and we know that the code has been audited. Why would the market care about the rest of the disclosures provided or required, rather, by the SEC? If the market doesn't care about those additional disclosures and additional costs that the issuers would incur just drafting those disclosures, and based on those disclosures being subject to extra liability under the bare pro plaintiff Securities Act liability regime, why would the market award issuers for that if they don't care about Regulation SK and the Securities Act? They focus on completely different data points, and this is how they value the project. That can be one explanation. But we always have to remember that there are the unsophisticated. We can divide the market into the sophisticated, who actually look at the code, and the unsophisticated. And the unsophisticated are never properly protected in either private placements or crypto placements, for that matter. They simply don't understand the code. And this is the category which may benefit from some level of comparable and mandatory disclosure, but it doesn't mean that disclosure should come from what we have at the moment.
Right. Could it be that the SEC is interpreting its mission differently than the way we're seeing it? For example, with regards to disclosure, they could say that for us, adequate disclosure means that it is a regulated disclosure pursuant to our forms. So if it is filed with the SEC, then it has greater assurances than if it has not. Or, we regulate different standards for investors. Retail investors require greater protection than other classes, or for market efficiency to go on. The SEC might say, they don't have a responsibility for market efficiency if it doesn't regulate that market. They only care about market efficiency for the markets which they regulate. So if it goes up in smoke, it doesn't really matter, because if it still meets its goal for the regulated market, then that's all that matters.
Well, they do regulate all securities markets, even secondary trading. They do that. So they should be interested in market efficiency, and they should realize that market efficiency is beneficial to all. And I'm not talking about fundamental efficiency. I'm talking about informational efficiency. If a market has a certain level of integrity, meaning there is a minimum amount of fraud, if a market has a significant number of gatekeepers and professional players, the information about, let's say, a firm or a project gets embedded into the asset prices really quickly. So, and everyone benefits from that in the end. And the SEC does and should care about that, of course. But in terms of the regional mission of the SEC, so it's a humongous agency. It has, as I mentioned before, one of the largest budgets among its homologues, its counterparties abroad. It's really big. Also, its sprawling bureaucracy has multiple divisions, including the division of enforcement. Is the division of enforcement doing a good job in crypto? Yes. The answer is yes, but they're using slightly different metrics. They are properly and diligently enforcing the law as we currently have it, right, on the books. They are not looking at the overall implications of this enforcement policy, which has become an enforcement program. And consequently, it has policy implications. They're not looking at that, and it's not their job. Instead, they're doing their job really well. They're looking at the law, and they're enforcing the law. And I believe it is the job of the policymakers in the Commission to look into this whole problem holistically. And because I, as I mentioned before, have deep respect for the Commission, And I think it's one of the most important capital market regulators, in part because of its extraterritorial jurisdiction. So sometimes it's serving as a good police officer for the rest of the world as well. Hence, we have a problem. We need to make sure that there is, let's call it the goodness of fit between the market and the regulation that we apply to that market. At the moment, we just don't have.
And this is where we ended the first episode with Professor Guseva. In our next episode, we're going to talk about how focused the SEC should be on protecting incumbent participants, digital asset intermediaries and marketplace regulation, the accredited investor standard and private placements under Reg D, as well as crypto disclosures and offering statements, and how the securities registration regime worked out for Blockstack, which filed a registration statement and then a couple of years later withdrew it, as well as what that registration statement meant for its board, and the challenges of complying with the disclosure regime for registered securities.